Thank you so much, everyone. Let's get started with our first conversation. So the federal government has made it clear that it will follow due process in handling major knotty issues, and there are a lot of those issues in the land. There are different legal tussle between the federal and state governments. Issues of anti-corruption is also there. So tonight we begin the conversations with an exclusive chat with the Attorney General of the Federation and the Minister of Justice, Abubakar Malami, Senior Advocate of Nigeria. He joins us from New York. The AGF, thank you so much this evening for joining us. Let's begin the conversation from some of the things that you said recently. You talked about the recovery of 200 million pounds looted by former public officials and stashed in the United States. Can you give us more clue as to those who are behind this? Because from what you said it was these monies were stolen by past officials. Between when and when did they steal this money?
Well, Sean, let me begin by way of saying that the way these things operate is we are very mindful, first, of the fact that there is need for some level of confidentiality, taking into consideration the multinational engagement associated there too. And then two, we are not interested in allowing for certain perhaps preemptive disclosures that may have the capacity of undermining what we are doing. But at this stage and at this point in time, I think what matters most before the execution and indeed the signing of the mutual agreements for the repatriation of this money is the fact that we are indeed pursuing further recoveries, and the recoveries are within the region and zone of around $200 million. And we are making progress in the sense that the parties of interest, that is the multinational engagement in issue, by that understanding, parties have agreed to develop some draft agreements. One part of the agreement is indeed being developed by the Department of Justice, United States of America, and the other side of the divide, which is the federal government of Nigeria, is equally expected to foot up a draft agreement for consideration and further deliberations among the parties. And we are looking at the possibility of reconvening sometimes in October for the purpose of taking up the process of such negotiations. But one thing that is fundamental, as has been the tradition, at whatever point we now come to terms with the reality of endorsing or executing the respective agreements, much disclosures and indeed comprehensive disclosures associated with the parties of interest, associated with the asset and the volume will certainly be disclosed. But the major consideration arising from the understanding among the parties is some level of confidentiality, which I wouldn't like to breach arising from the common understanding of the parties. But the amount involved is within the region and zone of around $200 million.
That's a lot of money, considering the state of things in the world now. That would do a whole lot if those monies are repatriated. But a lot of people are anxious. They want to see that money come back to our shores. And for those who believe that it's getting rather sluggish, how soon can we get this money repatriated?
Well, I do not agree with you, particularly as it relates to the use of the word sluggish, taking into consideration our antecedents associated with the recoveries recorded so far. As you rightly know, this recovery process has been a process. It's a process that has been on for over 20 years, and within the period this government comes into office, we have succeeded first in making multiple recoveries. A recovery of 322 million, sometimes in 2017, a recovery of 311, sometimes in 2020. And associated other recoveries within the region of 78 million pounds from UK, among others. So within the context of the fact that we have been embarking on aggressive recoveries, which had indeed recorded repatriation of such recoveries to the motherland, the idea of using the word sluggish as far as this government is concerned in terms of recovery, I think is an unfair assessment or perhaps an unfair logical deduction that cannot stand with the consideration of the recoveries effected. So we have been working wonderfully well in terms of making recoveries. And I think within the context of the international appreciation of issues, Nigeria as a country is the only country that has succeeded in having this much recoveries within a shortest period of around 6 years. So I think the word sluggish is an unfair a choice of word that cannot stand the test of time, having a regard to the successes recorded by a government of President Muhammadu Buhari in terms of recovery, and indeed in terms of deployment of the recovered assets to the infrastructural development and indeed social development in the country.
Those who are familiar with this kind of international engagements know just how difficult they say that the wheel of justice grinds slowly. So the use of sluggish is also within the context of how this is a multilateral engagement, which is not really within the powers of Nigeria. But also, I know at some point, the federal government, your office, has also appealed to other countries of the world to be helpful in getting these funds back to Nigeria. So when some Nigerians who are anxious to see these monies come back, I think that maybe some other countries are sluggish in their response, and that's why the term sluggish come in the sense that maybe not on the side of Nigeria. Are you getting the kind of response from other countries in getting some of these funds? So perhaps there is a bit of a pushback from other countries. Are you experiencing such pushbacks?
Well, you see, Nigeria has indeed demonstrated a greater capacity in terms of mobilizing international support, international direction as far as processes and procedures relating to recovery of illicit assets are concerned. And with that in mind, other countries in the world have been supportive of what Nigeria is doing, both in terms of building consensus relating to processes and procedure that naturally makes it easy for repatriation of this asset. So I think Nigeria has demonstrated greater leadership capacity in that direction, and is making advanced a kind of a collaborative approach to it by way of gathering necessary support among the international community in terms of moving the process, in terms of developing international resolutions, in terms of agreeing on international processes and procedures that have the capacity to now kind of provide a platform whereby we can have illicit assets adequately and speedily repatriated to their countries of origin. I think within the context of what Nigeria is doing in terms of developing international consensus building and resolution, I think there are a lot of progress being made with particular regard to speedy repatriation of assets.
Before I come to how these repatriated funds are being utilized and where they are and the issue of transparency, let me ask, let's get an update on the looted Ibori, the Ibori looted funds. You told us some time ago that you're working hard in getting the other tranche of it back into the country. What is the latest on that?
Well, we are still negotiating, discussing, and these assets being considered for repatriation, I am talking of the $200 million, it constitutes part of that asset. So we are aggressively pursuing things from multiple directions and from multiple personalities, from multiple corporate bodies, and we are making progress in that respect. The progress we are making as it relates to the exchange of draft agreements for consideration, for deliberations and negotiations are all part of it. So Ibori's and associated Alamesia assets, among others, are all part of the assets being considered for repatriation, and the $200 million I'm talking about constitute a fraction of such assets.
Okay, so it's interesting. So, what can you tell Nigerians of those who have received some of the news stories of the repatriation with restrained optimism as to the loots and how the possibility of some of these loots finding their way back, being looted again? What assurances can you give Nigerians and about the state of these funds and the assurances that they are not being relooted and where those funds are being utilized? How can we track them?
Well, in terms of assurances, I think our conduct as it relates to the recovery is taking into consideration that we have indeed given the Nigerians commitment that we'll we'll take effective steps in terms of recoveries, and eventually we succeeded in making such recoveries. It's enough assurances that we are indeed doing the needful and we are pursuing such assets with the desired aggression. In terms of deployment of the assets, I think we have equally demonstrated a clear commitment which has come to pass as a reality of the situation. As you rightly know, the first tranche of $322 million recovered from Switzerland was substantially deployed to social investment programs of the federal government, the N-Power, the school feeding program, the trader money, and associated programs of the federal government that have succeeded eventually in bringing some level of succor and indeed some level of support to the less privileged, to the poor in the society, and demonstrated our commitment to deploying the resources in line and in tune with the agreement reached with the international community. As it relates further to the $311 million that was eventually repatriated, recovered in 2020, you know very well the commitment of Nigerian state under the leadership of President Muhammadu Buhari was to have same deployed in infrastructure. And eventually, what we are witnessing today between Abuja and Kano in terms of road infrastructure, the money was, part of the money was indeed deployed in that project. Part of it as well was equally deployed in Lagos-Ibadan Expressway, and we are living witnesses to what progresses have been recorded and made in the development of the road infrastructure associated with it. And above all, the second Niger Bridge is equally a living witness of deployment of such a recovered asset. So as far as the government of President Muhammadu Buhari is concerned, I think it has never been a story of relooting the asset, but a story of applying and indeed deploying the asset in line with the international agreement, in line with the best practices, and deploying them in such way and manner that the Nigerians can visibly see the effect and impact of such recoveries being made in terms of deployment, in terms of application, and indeed in terms of visible development, both in terms of infrastructure and in terms of improving the living condition of Nigerians.
This government says one of its major agenda is to fight corruption and to fight it hard. What then do you say at Honorable Attorney General to those who believe that corruption is even more rampant these days?
Well, it depends on your assessment, or perhaps maybe, but then one thing that I can tell you clearly that the government has recorded tremendous success as far as the fight against corruption is concerned. One, if you are looking at the fight against corruption from the point of recovery, I have stated that we have indeed succeeded in recovering first a large sum of $322 million and then additional sum of $311 million, and we are pursuing additional sum of around $200 million. So within the context of recovery, that is a clear demonstration of the fact that the fight against corruption embarked upon by President Muhammadu Buhari is paying off in terms of recovery. If you are looking at it from the point of policy and a kind of a technological deployment of policies, for example, what we have succeeded in doing as it is, for example, in terms of blocking the leakages associated with financing and funding of terrorism is a clear indication of the fact that we are recording a lot of successes in terms of fight against corruption. Look at the issue associated with legislations as well. We have put in place a lot of legislations, the effect and impact of which is an attack, a frontal attack on the fight against corruption. And if you are looking at it from the perspectives of prosecution and conviction, this is a government that has recorded indeed higher profile prosecution and conviction of higher profile individuals. So within the context of legislation, within the context of policy, within the context of recovery, it is indeed not a fair assessment of the success associated with the fight against corruption under the leadership of President Muhammadu Buhari for anyone to judge the fight against corruption as being cosmetics. It is indeed a fight that one can visibly see with real evidence on the ground and evidence associated with improved legislations and evidence associated with allowing the institutions to now do their job without fear or favor, as against a situation where we have had before, where individuals are more stronger than the institutions. Our institutions, the fight against corruption institutions in Nigeria are now more stronger than any individual, and arising therefrom, they have recorded tremendous and unprecedented convictions of high-profile personalities. So is it about legislation? If it is about legislation, you have in place stronger legislations. Is it about institutions? If it is about institutions, our institutions are now more robust and aggressive in terms of the fight against corruption. Is it about recovery? If it is about recovery, you can see for yourself what we have succeeded in recovery. What of the policy? If it is about policy, the VVN
let me perhaps come to the issue of, let's wrap up on the issue of anti-corruption briefly before we go. The Delta State matter on the Ibori loot, how have you been able to resolve it between the Delta State government, who said they want that money to come to them? Have you been able to resolve the matter?
Well, the recoveries were made in the name of the federal government, as you rightly know, Shehun, and not in the name of Delta State. So with that in mind, as far as the Office of the Attorney General is concerned, whatever is recovered on behalf is a recovery on behalf of the federal government and not on behalf of a subnational. So with that in mind, you cannot outrule the possibility of engagement, but then the fact remains that the agreement signed with the international community at the point of such recovery was an agreement that borders on Nigeria as a focal consideration and not a subnational. So the true position of things is with the agreement signed, what was in consideration was Nigeria as a victim of crime and not a subnational for that matter. So the fact remains that Nigeria was a victim of crime, and it was with that understanding that international negotiations were engaged and then recoveries made arising therefrom. So that stands the position of the federal government, but you cannot rule out the possibility of associated negotiations. But the fact remains that the victim of crime is the federal government, and recoveries were made on behalf of the federal government, and an agreement was signed between Nigeria and indeed the international community in relation to such repatriations, with the understanding that Nigeria was the victim of crime and the beneficiary.
All right. Let me go into those funding terror in Nigeria. UAE, for example, named names, but the federal government has said, no, we don't want to go that route. We want to get to the root of the matter. But what is the timeline in terms of investigation, prosecution of these terror financiers? Bring us up to speed on the prosecution.
Well, Shewin, investigation, as you rightly know, is something that you can not a kind of give a clear timeline as far as its conclusion is concerned. But one thing I can tell you clearly, that we have indeed embarked on aggressive local and international investigation of terror funding. And indeed, our investigation is yielding the desired result and fruits arising therefrom, arising from the investigation. A lot of people were taken to custody through the judicial process of obtaining a court order. And with that in mind, with the fact that the court orders were obtained in taking people into custody for the purpose of investigation, the fact remains that the matter is a matter that has been submitted to judicial process. And with the matter having been submitted to judicial process, it is a clear position that no action both in terms of release and otherwise, can be possibly effected without recourse to judicial process. But one thing I can further tell you, there can never be any release without recourse to court, and no release has been effected. So the fact that some people are insinuating, mischievously for that matter, that some people, some individuals were released is not true, and it couldn't have been true against the background of the fact that this indeed a judicial matter, and the fact that they were taken to custody arising from judicial orders, it only accords with common sense and reason that you can only release them with, after having recourse to judicial process, and no application for release was ever filed by the Office of the Attorney General seeking for release for a single individual associated with an allegation of terror funding and financing. So the fact remains that we are making progress both in terms of investigation, in terms of prosecution, and in submitting the matter to judicial process.
Let me jump quickly to other matters. On the issue of the value-added tax, VAT, give us the interpretation of the court, the outcome of the court processes based on at least the last one that we know from the point of view of the federal government. Because as it stands right now, nothing at the moment precludes the state from collecting VAT.
Well, a lot has precluded the states from collecting VAT. One, generally speaking, as you rightly know, the issue of value-added tax is an issue that is within the exclusive legislative list. And the implication of being an exclusive legislative list matter is that only the National Assembly can legislate thereon. So the question that you may perhaps wish to address your mind on is whether there exists any national legislation that has conferred the power on the states to collect value-added tax. And my answer is no. In the absence of a law passed by the National Assembly in that direction, no state can have a valid claim to collection of value-added tax. The responsibility, right, and constitutional powers to legislate on collection of value-added tax is exclusively and constitutionally vested in the National Assembly and not in the state. And where the National Assembly has not passed any law in that regard authorizing the states to collect value-added tax, then it goes without saying that no state can arrogate unto itself the powers to collect value-added tax. That is indeed the position of the federal government. But then over and above that, the fact remains that the matter has been submitted to judicial process for determination, and a position has been taken by the court that status quo should be maintained. When you are talking of status quo, as far as the collection of value-added tax is concerned, is a position before the parties submitted their dispute to judicial determination, which position is clear that the Federal Inland Revenue Service, which has been the agency and institution invested with the power arising from the from the law passed by National Assembly, should be the one responsible for such collection until after the matter is eventually determined by the court. And then again, the federal government had equally taken a decision to approach the Supreme Court, because once a matter involves a dispute between a federal government and indeed a state government, the proper forum, the proper court with such jurisdiction is not a high court of a state or the federal high court, but indeed the Supreme Court. So the federal government is instituting an action for this matter to be settled and determined once and for all, and certainly will submit to the jurisdiction of the Supreme Court for the purpose of having this matter determined.
Minister, you were explaining the position of the federal government. For some states who believe that the VAT, they are going to go ahead to collect it. In fact, at the end of this month, they will be collecting it. How do you react to such?
I believe we have in place a constitutional order that is indeed with all the states and indeed the federation are bound, one, by prevailing legislations relating to the issues. And above all, the parties have submitted their grievances to judicial process. So I do not see any state of perhaps taking the law onto its hand without allowing the judicial process to take its natural course and in breach of the prevailing legislations. So I do not see the states acting arbitrarily and setting a very bad precedent as far as the governance is concerned, with particular regard to the fact that the matter is indeed receiving judicial determination. I cannot understand, I cannot perhaps bring that thought into consideration, and I believe it could amount to a high level of recklessness on the part of any state government to be operating in breach and to be operating a lawless governance style as far as the Nigerian state is concerned.
But how is the federal government planning to amend the constitution? Because there seems to be a kind of a vacuum or a silence or lacuna in the law. It's not specified as relating to the VAT, especially in the tax law in Nigeria.
And I believe it is only natural and accord with common sense that the National Assembly, which is the institution responsible for such amendments, should be allowed to, to do its work, and any grievances associated with a demand or a request for constitutional amendment should as well be channeled through the National Assembly process. So what I'm saying, in essence, you cannot out the possibility of allowing a due process to take its course, which could be either legislative or judicial. But certainly it doesn't accord with reason for any state government to take the law into its own hands without allowing the judicial or legislative process to take its natural course.
What I'm trying to say is that there is, in the legislative process, there is what we call the executive bills, which can be translated from the executive arm of government to the parliament to amend a certain aspect of the constitution. Will the executive, your office, the federal government, the office of the president, will it be transmitting is there a possibility of that, sending an executive bill for the amendment of that section for a clarity for future purposes?
As far as we are concerned, we have not seen any lacuna associated with the law. The constitution is clear that the power to put in place a law relating to the collection of value-added tax, for example, is exclusively vested in the National Assembly, and it's an issue that is embedded in the exclusive legislative list. So as far as the federal government is concerned, no such lacuna is visibly seen in the Constitution, and it is not our resolve to make any recourse to National Assembly by way of presenting an executive bill. We have no such intention, and we are happy with what is on the ground, and then we'll challenge the purported request of the purported laws put in place by some states that are targeted at undermining the existing legislative arrangement. The law, and indeed the Constitution, has indeed covered the field as far as the issue of value-added tax is concerned, and we do not announce any intention or perhaps desire to put across any legislative bill in that direction.
To conclude now, let me take you to some of the agitations. I know you are in New York, you're with the president, and we've seen pro and anti Buhari or FG protests on the ground there at the United Nations General Assembly, the free will of people to protest and air their views on what they think. And we've been saying these agitations across the land, the ethnic, sectional agitations across the land. Is the federal government, through your office, considering a political means of dialoguing or discussing the issues with concerns persons or section of this country?
As I cannot rule out all possibilities, the one thing that is clear is no such considerations are on the table as far as the position of the government is concerned. But about the agitations, I think the agitations are international. If you are in New York today, even China, you can see there are people from China, they're pro, and I mean, those that are propagating and those that are an agenda and those that are against it are on the street. If you talk of other international, other countries in the world, inclusive of Senegal, they are all there out of the street and demonstrating. And it all boils down to the issue of freedom of association, which Nigeria has equally been tolerating over time, both locally and internationally. So it is about expression of freedom of expressions, which forms part of our constitutional law, which we have agreed as a nation to tolerate, and then you cannot stop them from agitating. But as far as reaching out in terms of, providing any reconciliatory framework is concerned, I think there is no serious, source of concern, more so when people, as far as the Nigerian state is concerned, have chosen, among others, to submit their grievances to court of laws for determination. So I think the existing platform of judicial and extrajudicial, inclusive or legislative, have provided a wider platform for those that are agitating for one concern or the other, one grievances or the other, to put across their grievances for consideration, either through legislative or judicial means, among others. So with that platform in mind, I think the idea of reconciliation does not even come into place because nobody is fighting, but it is about expression of opinion. It is about constitutional tolerance against the background of the constitutionality of freedom of expression.
I'm asking this question on the backdrop of these agitation and this call for self-determination that is permeating across the land. And the Sunday Igboho case was there in Oyo State, which the federal government, you reacted to it in New York, and the consideration of the fact that how can we stem the tide of these different agitations that are causing unrest in the country. The strategy of this government, is it only by legal means or extra legal means, in the sense that are you looking at political means of resolving this matter? Is that a concentration, or the federal government just want to use the legal means to fight this battle out?
Well, the major consideration of the government is legal and legislative means. Those that I believe in the change in the constitution or amendment thereto can approach the National Assembly. Those that believe that their grievances are judicial can approach the judicial system. And the fact remains that this government is not interfering in the judicial and legislative process of the federal government. So whoever is considering means that is not that is outside the scope of the legislative framework or perhaps legal framework is perhaps agitating out of the bounds of the Constitution, and then the law must naturally take its course in terms of ensuring that people operate within the ambit of the law.
So I was going to ask you, just two brief final questions. In the case of Sunday Igboho, have you approached the appeal court? Because you said that you're going to challenge the matter and probably bring up more suit against him.
Sorry, Shaun, my next appointment is at 3, and we are in agreement. I need at least 10 minutes to get to the venue of the next appointment. So can we kindly bring an end to these discussions? Maybe perhaps we may consider some other time to address other issues in case there are others that you feel strongly about. Kindly accept my apology over this.
It's fair enough. Thank you so much for the time that you spared tonight. Appreciate it. As Senior Advocate of Nigeria, the Attorney General of the Federation, and the Minister of Justice, Abubakar Malami. Thank you so much for your time. He's been speaking with us from New York on the sidelines of the United Nations General Assembly. Thank you so much.
Thank you, Shaun, for having me. Very grateful.